Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and obviously relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years' experience. With me tonight, I've got Nunzio Tartaglia, a partner in a law firm in compensation. Good evening, Nunz.
Tony, viewers, welcome.
And Don Maffia, who's a partner in transport accidents in a law firm. Good evening, Don.
Good evening, Tony. Good evening, viewers.
Tonight, viewers, we're going to be talking about something very pertinent, that is slips and falls in supermarkets and occupiers' liability.
Before we start, Tony, what's in the news?
Nunz, the first story is a case that you're involved in.
Yep.
Lisa Herod, this is a lady that lost her sight. Tell us a bit about the case.
Yeah, look, Tony, this was a case that ran, it was a jury case that ran before Judge Misso and the jury at County Court of Victoria just recently. Poor Louisa was at the Carlton Club, which is a well-known bar in Melbourne, in Burke Street. Was there dancing with friends. On the side of the dance floor, there was a planter box with effectively just plants coming out of it. She was with her friends dancing on the dance floor, bagged in the middle, as girls do. Leant over to get something out of her bag, and then because there was obviously plants coming out of the planter box, there was a pointy edge and hit her in the right eye, and unfortunately she's blind in one eye. And this was a case that went all the way to a jury verdict, and jury awarded her $1 million, Tony. It was 1.1, less 10% for the fact that they say that she contributed to the accident. Look, it was a great result for her considering how much she's gone through. So,
Don, the defendant bitterly contested this case on the basis they say it wasn't reasonably foreseeable that you could be injured in those circumstances. What do you say?
Well, I think they also said, Nunzio, correct me if I'm wrong, that the plant it didn't happen the way we say it happened, so the plant wasn't situated in that way that could cause this type of injury. So the defence, I understand, it didn't happen.
Yeah, look, there was evidence, Don was right, that it, the plant wasn't where it was, but there was footage of the accident, and it was clear with everyone in the courtroom to see that, she went for her eye straight away, and there's evidence to say she went to the hospital that night, with her mother and so forth, and it was clear that something happened to her in her eye. So, it was a bit strange the way it all panned out in that regard.
We might get her on the show at some time in the future, Nunz.
Oh, look, it is, and look, she's only sort of 21-year-old girl, great girl, and deserves it for what she's gone through.
And Nunzio, even though it's $1 million verdict, but because of the Wrongs Act maximum, it had to be reduced.
Yeah, judgment was only entered for effectively just under $500,000, Don.
Because she's still working, isn't she?
Oh, look, she's got capacity to work, and the maximum that you can get under effectively pain and suffering in Victoria is just under $500,000 now, so that's where judgment was entered for that amount. So,
all right, look, we'll come back to this story. Let's keep moving. Don, tell us about the windfall the fitness student got for his dodgy knee. What's this about?
This is I believe it happened in Canberra, where this fitness student, he's 56 years old, he goes to a fitness course, and they made him do what's called jumping squats. I've never done it before. I'm not sure if any of you have. I think you start from the ground trying to jump up, and he's done his knee, pretty bad knee. In fact, he needs a left knee replacement. And he got a judgment award of damages, I think $150,000 for general damages, and the rest made up about $100,000 of expenses, economic loss and medical expenses as well.
Nunz, the defendant tried to argue that he signed a waiver and the judge said, no, I'm not having any of that nonsense. Yeah. What's that all about?
Well, effectively the judge said you can't contract out of negligence, and, look, you go to amusement parks, you go to anything these days, and, a lot of occupiers try to get you to sign disclaimers that, you can't sue them for anything that happens to you. Look, that, even though there is some merit to that, effectively it's almost impossible to contract out of negligence, Tony, which, look, I agree with.
And that jumping squats they're doing is literature to say it was a very dangerous type of sport and or exercise that they do. So you just can't say, sign here and there you go, we've got no liability for you.
Can I ask you this, Don? This fellow settled a claim for the same knee when he took a fall in Bunnings the December before. where he damaged the same knee. Was his knee already weak? Would the next person have had the same problems as him?
The evidence, we haven't been shown with all the medical evidence, but I suspect, in my experience, Tony, where maybe he does have susceptible knee to further damage. In these cases, the defendant has to take their victim as they find them. So the fact that he's had a weak knee doesn't necessarily mean they're not liable for it.
Look, and the judge thought he's actually a pretty fit man and obviously trying to undertake sort of personal trainings. But look, it's a big award at that age too. So, he'd be stoked with that.
And what was significant was the fact that the people that conducted the exercises were professionals. It wasn't just some bodgy backyard operation, was it?
Yeah. Look, they gave conflicting evidence that they were doing, I think, was it half squats? Look, there was obviously a factual dispute, but the plaintiff was believed.
And he had to bend his knee over 90 degrees, which is pretty harsh, isn't it? Yeah. Look, let's keep moving. There's a bike ban call for children riding these quad bikes. Nunz.
Yeah, look, there's been numerous deaths. I think 18 deaths in a year because of these quad bikes, and there's pushes to ban them, which, look, understandably, because of the amount of deaths. What's your take on it, John?
It's children on these quad bikes, Tony. So they're not just adults. They're children. The numbers of children on these quad bikes, generally in farming properties, they're helping out parents do the farming, that find themselves in these type of situations, injured, and they end up in hospital. And because the quad bikes are much heavier than your two-wheeler motorcycles, they're susceptible to further damage or to injuries.
Well, apparently they've got a propensity to roll. I would have thought that being on four wheels, they wouldn't roll as much, but I can't understand that. Maybe they need stabilisers or something like that.
Look, I was the same when I was obviously looking at the articles. I also thought that with four tyres or four wheels, you think that it makes it a little bit safer, but maybe not.
Well, not necessarily. I mean, they're much, like I said, they're much heavier than a motorcycle, two-wheel motorcycle, and it depends on the balancing when you're turning all that. It's probably easy to flip over a four-wheeler than a two-wheeler, the balancing.
Well, let's move on. The TAC aren't paying their bills in full. Well, Don, this is something you should be able to tell us
Look, it
about.
is. Unfortunately, we find ourselves in a situation where the TAC have a schedule of rates that they pay to doctors. So when you go to doctors and the doctor charges you, TAC only pay, it appears to be a portion of those bills, similar to like the Medicare scheme. It's been an ongoing issue. There's been a public inquiry into why that's happening and why there's so many doctors out there that charge us above what appears to be the Medicare rates.
What I think they should do, Don, is what they've got in Adelaide. They set a prescribed rate and the doctors have to charge that and the insurer pays it.
What, for like a transport accident injury?
Transport, work accident, They set a prescribed rate, that's what they can charge and they pay it, that's it.
Well, look, something that's been done because this does affect the victims in this case.
Of course.
They go to doctors and they can't afford. They're not working because they're injured, of course, and they go to doctors and they can't see the doctors because doctors ask them for upfront fees or they charge a lot more than what's been paid back.
Why don't we get someone from the Transport Accident Commission to come and explain the situation?
Well, we'd have to, because I think they're recently announcing that they're struggling financially, so we'll have to be a good topic of discussion.
All right, just quickly before we go to a break, what about this stunt where they've driven from Melbourne to Sydney in 6.5 hours and they cut nearly an hour off the drive? What do you think about that?
Look, I know we're going to go to a break, but look, I think there's some merit in the fact that sometimes, to the theory that I suppose the high speeds does create less accidents, but I know that TAC doesn't promote that.
It's breaking the law. I mean, 130 k's, that's 20 kilometres.
We should get the TAC for this episode as well, talking about the higher speeds.
I think just what's interesting is that the guy who done it was from Britain, so they didn't get a local
so he couldn't get charged.
So couldn't get charged. So.
Viewers, we're going to go to a sponsors break. Please stay tuned. After the break, we're going to be talking about slips and falls in supermarkets, which probably encompasses the majority of the population, so don't go away. Viewers, welcome back to the show. This week's episode is about slips and falls in supermarkets and also when you attend local shops, occupiers' liability. Nunz, can you give us a general spiel about what we're talking about today?
Well, effectively, Tony, slipping cases are probably the most common form of accidents outside, I'd say, work cover and TAC accidents. Unfortunately, there's a lot of people that go to supermarkets every day. There's things on the ground, whether it be grapes, water, soft drink, hot chips, shopping centres everywhere. Unfortunately, it's always happening. And if you do sue, you do have if you do slip and fall, you do have the ability to sue if you can prove negligence.
And Don, in a lot of the cases we're looking at, it's not a question of chips and grapes and whatever. It's the employees mopping and leaving too much water behind.
Yeah. So it's
which
substance.
creates another hazard.
Yeah, of course. And there's substances on the floor. The water's probably the worst,
Yep.
I would say, because you can't see it.
You can't
Clear
see it.
floor, you see it, walk over it, slip. And they sustain quite nasty injuries because it is a big fall.
Yeah.
And Nunzio, in your practice, you use a lot of expert witnesses say the force that's used when you slip and fall down.
Yeah,
It's
look,
quite significant.
that does play a part. And I suppose the misconception is that people think that as soon as you slip and fall that you win. Unfortunately, so that's not the case. It'd be great for plaintiffs because then those who suffer injuries would get money for those instances. But the main part of it is you've got to show that the occupier, whether it be a Coles or a Safeway, Woolworths, have breached their system of cleaning or breached their duty of care, and that's what needs to be proven in order to win your case.
Don, a lot of these cases, they're all governed by the Wrongs Act.
Yep.
What's the Wrongs Act, Don?
Well, the Wrongs Act is a Victorian legislation that codifies pretty much the liability, or in this case, occupier's liability, what it means. And so it pretty much sets out the basis of negligence, what you need to prove to get an entitlement. Thresholds as well, Nunzio, as to, so if you slip and fall, you don't have a substantive right to sue until you have what's called a significant injury.
Which means, viewers, you've got to have 5% whole body impairment for pain and suffering, albeit if you're suing for loss of income or medical expenses, you don't need the 5%.
And also home help, Tony.
And home help,
Yeah,
which is pretty big and home help doesn't encompass you getting outsiders. It could be family members assisting you to clean the house, vacuum, clean toilets, showers, hang up the laundry, cooking, shopping, that sort of stuff.
Yeah, and all you need to, I suppose the requirement for that is you have to show that you've received that help for at least 6 hours a week for 6 months. And most importantly, as Tony said, it's got to be the fact that you were doing it prior to the accident, but now you're not doing it because of your injuries.
And that could be a significant sum.
A verdict a few years back for about, I think, just under 100,000 for a, effectively what's called G&K claim, effectively a home help claim. So they can be very sizable.
Oh yeah, because what you do is effectively look at the assistance that a person will need throughout the course of their life.
Yep.
Because in a lot of instances, it's not something that goes away. It's a situation where you might need someone to assist you to shop or clean or do the laundry. Yeah, gardening.
And sometimes, I think, plaintiffs or clients get fixated on the suffering they had in the past, but they've got to look at the future. That's where the big sums of money are, and that's why when you work these things out, it extrapolates into the future, and they can come to quite big sums.
Exactly.
So,
Look, let's go to our first case. Don, Fitz Simmons and Coles. It's a 2013 decision, so it's very recent. Tell us a bit about the facts of this case.
This is a New South Wales case. Now, I think tonight we're talking about all Coles cases. I think that's just a coincidence.
We don't have it in for Coles, so please don't start bringing it up and having a go at us.
This is a case where some employees found a dirty patch in a Coles supermarket, and there's 2 employees, and they came down with a mop to clean it up, but they were using a new mop. So for some reason, a new mop wasn't soaking up all the water, so it left a wet patch. And they put up 3. It came out in evidence. I think it said 3 little, wet signs, triangle signs around it. So meanwhile, one of these employees went to go get some chucks or something to wipe it up, to mop it up, and the other employee, it doesn't really say where she was, but she wasn't standing around. Meanwhile, in between that time, Mrs. Fitz Simmons comes along, doesn't see the signs, slips and hurts herself.
There's signs up. I mean, really, what more could the supermarket do? I mean, I would have thought, and traditionally, if you got signs saying watch out, wet floor, that should suffice, surely.
Look, Tony, in the first instance, the court, I suppose, took your position, but then on appeal they didn't. And they said in this instance, it came down to what she was doing. She was holding a young child. She was looking at the aisles, I think looking for a birthday cake. She was arguing with her partner at the time. So effectively, she was doing everything but looking where she was going, and she didn't see the warning signs. And
all right, just based on what you said, so if she wasn't arguing with her partner, she wasn't carrying the baby, she would have lost her case.
I think she probably would have, because really she probably would have seen the warning signs in front of her and would have avoided the effect of the slippery substance.
I mean, I think when you go to shopping centres, I mean, everything's above eye level. I mean, the idea of the aisles in the shopping centre, the way they're set up is to get your attention. So they'll be at that level. So when you walk in, all your attention is immediately diverted to the stands, the signs, the sales signs and all those things. So, look, I go shopping every week and you just do get distracted because you've got all these things going on. So, look, I don't know if, and look, I agree with the Court of Appeal, 3 little signs is enough when it's on the floor, when it's blatantly obvious that there's a big wet patch and someone can walk through it. So I agree with the Court of Appeal on this.
And sometimes you find with warning signs, Tony, I've had it in many cases where, look, I know in this instance they have 3, I'm not sure exactly where they'll place, but, sometimes there's a wet patch in front, they put a warning sign behind it, and the person thinks that the water or the slippery substance is behind the warning sign, but it's in front, and they slip. So warning signs aren't straight away a sign that you can't win your case. This proves that.
And
this was a bit of a vexatious, frivolous sort of claim because she didn't get any pain and suffering or loss of enjoyment of life.
Look, vexation, I think, is, to be honest, strong. I think the fact is that she couldn't prove that she had a significant enough injury to get damages for that, and ultimately said she was significantly out of pocket after this, despite the fact that she won.
She was awarded $1,800, which is what?
I look, because of New South Wales law, there are thresholds as well. But Tony, the court looked at the evidence of liability and the damages separately, as they always do. And on liability, they said that Coles was negligent. And the fact was that they had the extra employee who somehow went missing during the intervening period of mopping up and going to get the other employee getting the chucks or whatever, that she should have stood there and directed people away, having fully seen that this is a hazard. So, look, yes, Miss Fitz Simmons didn't get her damages, and I think that's more because she didn't come across as a, unfortunately, credible historian. But she did win a case on liability.
Tony,
I reckon
you're a plaintiff, man. You've gone the other way now. Supporting Coles, what's happening?
She got $856. They found she had 50% contrib. Viewers, we've got to go to a sponsors break. I'll come back to this just after the break. So please stay tuned. Viewers, welcome back to the show. Before the break, we're talking about the case of Mrs. Fitz Simmons. Now, she only got $856 because she lost 50% for her own contributory negligence. The relevance of this case was the lawyers wanted a precedent against Coles Supermarket because on all accounts, there was no money in it for Mrs. Fitz Simmons. In fact, she was ordered costs. She had to pay cost nods. So look, you would have thought the lawyers funded this to the Court of Appeal, didn't they?
I would have thought so. Look, from a financial point of view, I'd say both the lawyers and the plaintiff, it's a disaster. But from a future precedent perspective, it's important for future plaintiffs because, as you said, you could still have warning signs and still win.
And still win.
But in all fairness, I mean, if her evidence was accepted, the issue was her evidence wasn't accepted as to her injuries. She would have got in excess of over $100,000. Just she lost that causation issue with her injuries. She won the liability, but she lost the causation. That's why she got such a
She had no credibility from reading the judgment. She said she couldn't do things, but then she sat in the witness box for 3 hours. There was, a lot of conflicting evidence which didn't help her.
And look, the judgment at first instance, when you look at it, what the Court of Appeal said, it wasn't a watertight judgment in that sense. So look, Tony, I mean, if her evidence was accepted, they should have got easily over $100,000.
Look, if it was in Victoria, she probably would have got pain and suffering. The Civil Liability Act in New South Wales is a lot stricter after the amendments to the legislation a few years ago. Look, let's keep moving. Coles and Menedjello. Nunzio, you want to give me the facts of this?
Yeah, Tony, look, this is, again, another case at Coles where a client injured her shoulder when she fell at Coles. Look, the effect of the issue in this case is that after she fell, she noticed 2 pieces of small cardboard on the ground and that was her case. She said that she fell because of those small pieces of cardboard without any effectively, I suppose, direct evidence to that effect. It was more of an assumption, look, that must have been the reason why I fell.
Well, she put her feet on top of them, so that's a good start.
Well, that's what she does. She assumed
She did.
And that's where, unfortunately, that's where the case didn't succeed, because there was no direct evidence that she slipped on these, which I understand were like paddle pop sticks.
Yeah.
And she found those sticks after she fell.
Yeah, so I suppose if it was believed that, she slipped on those two pieces of cardboard, then look, I think she would have succeeded. I mean, obviously she succeeded in the first instance because I think she was awarded
119,000.
119 odd grand, and then on appeal she lost. So if that was believed, she would have received that type of money. But unfortunately it wasn't. And expert opinion was important in this case, Don.
It was important, but experts only as good as the proven facts, and it wasn't proven, or there was no direct evidence that she slipped on this cardboard.
Well,
So
just
his
on
evidence-
that point, one of the things that came out of that case was that a plaintiff must be able to establish on a balance of probabilities that the hazard in question actually caused their injuries. Discovering a potential hazard after the accident can be insufficient, especially without support and evidence such as a witness to say that you slipped on that thing that you say caused your accident, which is a cardboard.
Yeah.
She couldn't give evidence to say that she actually slipped on the cardboard.
Look,
that's why she lost.
And look, and I think that's, I suppose, a lesson to plaintiffs. It's important that that you're, I suppose, accurate and you're consistent with exactly what happened. Because obviously she wavered, because I'm assuming she would have went to a doctor, hospital, said one thing, did another. Don't know how I fell, and right there you're just putting doubts in the mind of the other side. And if she was consistent about what happened, I think this probably would have been resolved out of court.
The reality is, she told the truth. She wasn't sure.
Yeah, that's right.
Well,
but then at the same time, that's when I suppose the lawyer's got to make the decision. Is that a viable case?
But there was no CCTV that I could see. So CCTV, and we discussed it in the first segment of today's episode about the case of Herod, where CCTV helped that judgment. Here, there was no CCTV.
And even though they got the engineer in this case done, it means nothing because there was not enough evidence there to establish how she fell in the first place. So the engineer's not going to do anything to help her case.
I suppose, Tony, do you believe the theory, res ipsa loquitur, speaks for herself, the fact that she fell, she had to slip on something.
You've got to still prove what you fell on.
Yeah.
I mean, let's be realistic. You, as the individual, would know if you slipped, you tripped, if there's something that caused you to slide, you could feel it. You know what I mean?
Yeah.
Let's keep moving. Kissen and Coles. Dom, this plaintiff actually won. Tell us the facts.
In this case, Miss Kissen, she went to a shopping centre, again it was Coles, goes near the freezer section, slips on some water, and in fact what happened prior to her fall was that an employee had found that patch of water near the freezer section, and he went off to go get the sign, and that's when Mrs Kissen came along and slipped on the water.
Jeez, that's not much time, is it, Nunz, really?
No, but this case, the plaintiff succeeded on two bases. One, most importantly, it was a policy of Coles that if they do notice a slippery substance or on the ground, that one, they should effectively stay there until it's barricaded or there's warning signs, and they didn't do that. They just walked off, thought they'd get it, all the relevant either warning signs or mops and so forth, and left it.
So he took a chance, effectively.
Yeah, and look, that's a breach of their own policy, and also it also mentioned the fact that I think it was last inspected that area about, don't quote me, I think 3 or 4 hours ago. And in accordance with the High Court case of Woolworths versus Strongs, which is the precedent in any slipping cases, they breached their own system of cleaning. So they got him on two fronts, Tony.
Yeah, but the
it was a no-brainer.
Causative thing that led to the injuries was the fact that he wandered off to get a bucket.
That's the main argument, but they got him on two fronts. It was, to me, it was that decision had to be made.
Yeah, so look, he should have stayed there and just warned all the customers to not go across this water patch.
And what waited for an employee to come past and say, go and get a mop and bucket and I'll wait here? Anyway.
Well, that's what essentially the judge said in the case of Fitz Simmons that we spoke about earlier, where there was 3 signs, just wasn't enough. It should be an employee there just directing the traffic.
There's enough employees at these supermarkets, as we all know, that they can call somebody, they'll find somebody there. So, if that's their policy, Tony. So they breach their own policy. So if they don't like their policy, don't make that as a policy.
Viewers, even though 2 of the plaintiffs in these cases didn't get much money, these are very good decisions for as precedents for the future, because there's a lot of instances here where there's signs. Someone's wandered off to get some a bucket of mop.
Yep.
So they're very good precedents for plaintiffs. So not all is lost, although sadly Coles was the recipient of the verdicts in all three of them.
Yeah, in this case.
That's just unfortunate, isn't it?
Look, in this case, though, the plaintiff received, I think, just over 170 odd grand. So, look, it was a big award of damages, and look, I think she had some fairly serious injuries. So.
Don, we're getting towards the end of the show. Is there anything you want to tell the viewers?
No, I would say, look, if you have a fall or slip in a supermarket or restaurant or shopping centre, a couple of things that would take out of these cases. Obviously, witnesses, always witnesses. If you find your witnesses, get their names, get the details. Also, CCTV, because a lot of places don't retain the CCTV.
Yep. And Nunz?
Yeah, Tony, look, just to viewers, look, slipping cases are very prevalent, and unfortunately a lot of people do slip and fall in whether it's shopping centres, supermarkets, restaurants and the like. So if you have had a fall, do seek legal advice, because there are rights available to you.
And viewers, thanks for watching the show. Make sure you go to our Facebook page and Twitter and make some comments. I mean, obviously, everyone's got something to say about what we've discussed today. Also, go to past episodes. Stay tuned for future episodes. And always remember to stay safe.